Start the recording. Roll call. Dr. Fitzgerald,
Present.
Ms. Rucker,
Yes, I'm here.
Yvonne. Yvonne did indicate that she would be in attendance, so we'll check, watch for her. Mr. Harris,
Here.
Mr. Kaplan. And again, he did indicate that he would be in attendance. Mr. Kenny,
I'm here. I'll get the video
thank
going.
you. And hopefully we'll get Mr. Squire and Mr. Kaplan. But right now, you do have a quorum, Madam Chair.
Okay. Should we proceed?
Yes, we can proceed.
Okay. First item is the Pledge of Allegiance. Jeannie, would you be willing to lead us in the Pledge of Allegiance?
Sure. I pledge allegiance to the
the
flag
flag
of the
of the United
States
of America,
to the republic,
For which it stands,
one
one
nation,
nation,
under
under
God,
God,
indivisible,
indivisible,
with
with
liberty.
liberty
and
and justice for all.
There may be times during the meeting that I will ask you to unmute your mic so we can hear what you're saying.
Okay.
Is there any public comment? Okay. Moving on to the next item, approval of the agenda. Do I have to ask for a motion to approve?
Yes, please.
Okay. Would anyone provide a motion to approve the agenda?
I wish to move to approve the agenda.
Do we have a
I'll
second?
that. I'll second the motion.
Okay, motion approved. Draft minutes from February 5, 2019. Are there any changes or corrections?
I didn't get a copy of those, so I'm
Oh,
hesitant to vote on that.
okay, Jeannie, I apologize. I had attached it with the agenda.
I
There
got
should have
the
been-
agenda.
So there should have been 2 attachments.
Well, I will just withhold my vote on that.
Okay,
If everyone else is good with it, I'm good with it.
Did everyone else receive the minutes?
This is Richard. I don't recall that I did.
all right. We've been having some issues with attachments, so we can table those,
Okay,
get a motion to table those, and we can put them on the minutes for the next meeting.
okay. We will then table the motion to approve the draft minutes from February 5th, 2019.
And could I get a motion on that, Dr. Fitzgerald?
Yes,
I'll move to table approval of the February 5th, 2019 meeting minutes until the next meeting.
Second.
motion's been approved.
Thank
And
you.
it will be deferred until the next board meeting. Now we'll come into the case before us today. And let me read. The Air Pollution Control Hearing Board has been established pursuant to section
Oh,
020.
there's Kat.
.025 of the Washoe County District Board of Health Regulations governing air quality management, and section 020.0251 authorizes its jurisdiction in hearing appeals from any aggrieved person. This board is comprised of volunteers appointed by the District Board of Health who meet the qualifications required in section 020.025. Appeals heard today, April 9, 2021, will be forwarded to the District Board of Health with the recommendation as set forth in section 020.0251D and will be reviewed at the regularly scheduled meeting Thursday, May 27th, 2021 at 1 p.m. At the discretion of the District Board of Health, all appellants may provide further testimony regarding their case at that time. Appellants must indicate in writing in a letter addressed to the District Health Officer within 5 days of today's hearing that they wish to be heard at the District Board of Health meeting. Now, is there anyone that is going to provide testimony today that requires swearing in?
Dr. Fitzgerald, that will be our staff providing testimony. So it's my understanding that it will be Joshua Story. Mr. Jenkins will be providing testimony also. However, as a representative of the court, he does not have to be sworn in. And Ms. Downs and Mr. Kaplan have joined the meeting. So, Mr. Ristori, you raise your right hand.
Janet, I will be speaking as well. So do I need to be sworn in?
Yes, if you're going to be providing testimony, yes, you need to be sworn in also.
Okay.
So raise your right hand. You swear that the information that you're providing is true and accurate as you know it to be, so help you God.
I do.
I do.
Thank you. Dr. Fitzgerald, we can proceed with the hearing.
Okay, so we are going to be discussing today the appeal of the Reindeer Lodge regarding case number 1225. Staff recommends that the appeal be denied and the following fines be levied for violation Aqmv 21-0002 for violation of section 303.107 hazardous air pollutants of the Washoe County District Board of Health Regulations governing air quality management with a recommended fine of $4,000 for violation Aqmv 21-0003 for violation of 40 CFR 61 subpart M asbestos 61.145A with a recommended fine of $10,000. Violation Aqmv 21-0004 for violation of 40 CFR 61 subpart M asbestos 61.145B with a recommended fine of $12,500. And finally, for violation of Aqmv 21-0005 for violation of 40 CFR 61 subpart M asbestos 61.145C1 for $10,000. So that is a total of $36,500 recommended fine. The testimony today will start with a discussion by staff as to the violations, followed by questions by the board, and then followed by the appellant's case, and followed by questions by the board. And then the meeting will, that portion of the meeting will be closed and the board will discuss recommendations after that and have a final ruling. So if staff is ready to proceed with the presentation of their case.
Perfect. Madam Chair, members of the board, for the record, Francisco Vega, Director of the Air Quality Management Division. Thank you again for taking the time to discuss this case. I know we'd much rather be doing different things on a Friday evening. So again, thank you very much for that. Before I turn it over to Mr. Ristori, I just wanted to touch on a couple of things. First of all, being that I'd like to clarify that again, that we are here to, again, determine whether or not violations of county and federal regulations occurred. And it's kind of really that simple. I think the appellant will try to, ascertain to a lot of extenuating circumstances. But again, if you take just a plain reading of the regulations, again, we'll be looking to determine whether or not a violation of them occurred. And again, they may point to a couple of different things and use, fancy language, such as like detrimental reliance. But again, if you really focus in on the regulations and on the fact that a violation of those regulations occurred, I think you'll find in favor of us. So with that, I'll turn it over to Mr. Ristori, and he will be providing specific information on the case.
Thanks, Francisco. Good evening, Madam Chair, members of the board. For the record, Joshua Ristori, Supervisor of Permitting and Compliance for the Air Quality Management Division. I should note that I have been the project manager / inspector for the duration of this case. So what I'm going to do is present you with a, I'm going to provide you with a presentation of our case and the different violations associated with this case. And I'm going to do so by a PowerPoint presentation. Can everyone see that?
No.
No? Okay.
No, we can't.
Okay.
No,
We can see it now.
Can you see that now?
Yes, sir.
Yes.
So to start off, this case is case number 1229. It's involving Gary R. Schmidt and the Reindeer Lodge at 9000 Mount Rose Highway in Reno, Nevada, 89511. The topics of discussion today for our presentation, number one, what is Washoe County Health District's Air Quality Management Division's authority in this case? Why do we proceed with issuing violations for this case? We'd like to provide a brief history of the Reindeer Lodge. We'd like to provide some important definitions that we feel would emphasize our case. Also, potentially add clarification to the violations that we have presented. And then we'd like to go through notice of violation numbers Aqmv 21-0002 through 0005. So to start off with, what is the Washoe County Health District Air Quality Management Division's authority? So pursuant to section 030105B10 of the Washoe County District Board of Health Regulations governing air quality management, which are adopted, we adopt by reference 40 CFR 61 Subpart M of the Clean Air Act. And we have been delegated authority by EPA Region 9 to implement and ensure compliance with this subpart within the Washoe County Health District. The Aqmd is responsible for implementing the requirements and standards set forth by 40 CFR 61 Subpart M, in addition to local DBOH regulation 030107 hazardous air pollutants, which is a local regulation that we also implement and created for the use of monitoring asbestos demolitions and abatements in Washoe County. With that, I would like to give a brief history of the Reindeer Lodge. So according to our research, the Reindeer Lodge was originally called the Rosemont Lodge, and it was built in approximately 1957 from surplus military barracks from an Army depot in Herlong, Nevada. The facility consisted of a bar, restaurant, music entertainment hall, and approximately 4 to 6 rooms could be rented. It was purchased by Gary Schmidt in approximately 1971, and the facility continued to run as a bar, restaurant, music entertainment hall until it was closed in the early 2000s. Also, the property currently is zoned general commercial by Washoe County. I'd specifically like to point out the fact that this facility, the Reindeer Lodge, has always been used as a commercial facility for the entirety of its life, since its construction to when, unfortunately, the roof collapsed in 2017. So with that, I'd like to go over some important definitions that are found in 40 CFR Part 61 Subpart M in regards to asbestos. The first definition that I'd like to go over is demolition. So demolition means the wrecking or taking out of any load supporting structural member of a facility, together with any related handling operations or the intentional burning of any facility. Facility, I think, is a very key term in this case because it's being argued by the appellant that the Reindeer Lodge is not considered a facility. But it means any institutional, commercial, public, industrial, or residential structure, installation, or building, including any structure, installation, or building containing condominiums or individual dwelling units operated as a residential cooperative, but excluding residential buildings having 4 or fewer dwelling units, any ship, any active or inactive waste disposal site. I want to move to the bottom of this definition, which states any structure, installation, or building that was previously subject to this subpart is not excluded, regardless of its current use or function. I think this is very important to point out because the appellant may try to exercise an opinion that this was a primary residence of someone. Therefore, the definition of facility does not apply in this case. The next definitions that I'd like to go through are in regards to asbestos. And again, these are found in 40 CFR, Subpart 61, Subpart M. Friable asbestos material means any material containing more than 1% asbestos as determined using the method specified in Appendix E. That's a very important aspect in this because we are dealing with, in some cases, friable asbestos containing material in regards to materials that were found at the Reindeer Lodge. Non-friable asbestos containing material means any material containing more than 1% asbestos as determined using the method specified in Appendix E. That when dry, cannot be crumbled, pulverized, or reduced to powder by hand pressure. Again, another important definition in regards to some of the materials we're going to be discussing in this case. Regulated asbestos containing material means any friable asbestos containing material as previously defined. Category 1 non-friable ACM that has become friable. Category 1 non-friable ACM that will be or has been subject to sanding, grinding, cutting, or abrading, or in this case, or in these cases, I will point out Category 2 non-friable ACM that has a high probability of becoming or has become crumbled, pulverized, reduced to a powder by the forces expected to act on the material in the course of demolition or renovation operations regulated by this subpart. And Category 1 and Category 2 non-friable ACM. Category 1 non-friable ACM means any asbestos containing packings, gaskets, resilient floor covering, and asphalt roofing products containing more than 1% asbestos. Category 2 essentially is everything else considered non-friable. Category 1s were typically described specifically because those types of materials had a less of a propensity to release asbestos fibers if they were disturbed. Typically, they were found embedded in matrices that would not allow the fibers to be released, or bituminous matrix that would hold on to those fibers. Whereas Category 2 non-friables are typically things that are able to be crumbled or reduced to powder by impacts of demolition or renovation. And lastly, I'd like to point out the definition for owner or operator of a demolition or renovation activity. It means any person who owns, leases, operates, controls, or supervises the facility being demolished or renovated, or any person who owns, leases, operates, controls, or supervises the demolition or renovation operation, or both. In this case, we are considering the appellant to be the owner or operator of the demolition or renovation activity. So with that, I would like to start going through the notices of violation as proposed by the Air Quality Management Division. And we'll start with Aqmv 21-0002, which involves our local rule under the District Board of Health Regulations governing air quality management 030-107A. So pursuant to this regulation, the appellant failed to submit a complete signed copy of an asbestos survey report to the district and an asbestos assessment acknowledgement form obtained before any permit for demolition or renovation. The purpose of the AAA is to determine if an owner or operator has completed their due diligence to inspect and sample suspect asbestos containing materials for asbestos and provide that report to the AQMV. I'm sorry, I heard some noise there. Provide the asbestos survey report to the AQMD prior to disturbance of any materials associated with a renovation or demolition at an EPA-defined facility. Again, I'm going to emphasize the Reindeer Lodge is defined as an EPA-defined facility because of its use. past, present, and in the future as well. So there was a building permit that was issued by Washoe County, numbered WBLD 18-105119, and it was issued on April 6, 2018. And it stated investigative work to include recovery of historical building materials for the repurposing and structural assessment of the lodge portion damaged by snow. Possible removal of damaged portion of the lodge and roof debris with installation of non-bearing weather-resistant end wall. The following phase will include contractor applying for permits for any structure repair or stabilization as outlined by structural engineer. Now, again, I want to point out that this building permit was issued in 2018.
He said he wasn't getting
far
it that way.
before the demolition started, but also at the time that this was issued, a survey was not completed and an acknowledgement was not submitted to our department.
Thank you.
So a AAA was not obtained prior to the issuance of the building permit or performing demolition activity on or before June 10th, which is the date that we've determined that the demolition started. It was not obtained prior to the demolition or renovation activity on the structure associated with the facility at the Reindeer Lodge. The asbestos survey was conducted by Nova Geotechnical and Inspection Services on June 14th, 2019. And the survey was conducted after the start of demolition on June 10th, 2019. This survey, in our opinion, was triggered by our notification that this demolition had started and our communication with the appellant that a survey needed to be performed on the structure prior to any further disturbance of the structure. So an asbestos assessment acknowledgement form was applied for and obtained for the demolition of the Reindeer Lodge on September 12th, 2019. And you can see in your staff report under Aqmv 21-0002 attachment 2, a copy of that asbestos assessment acknowledgement form. And some things I'd like to point out at this point in this violation are that the appellant may argue that they submitted a renovation permit to Washoe County Building Department and that adequate notification was provided to the county when they submitted that application for the building permit. We as Air Quality are unaware of any state, county, city codes and regulations that absolve an owner or operator of a demolition or renovation project of any air quality regulations, both local and federal, when a building permit is submitted to a separate entity of the state, county, or city. Also, you may hear the appellant argue that the Air Quality Management Division is using selective enforcement in this case in requiring the appellant to obtain an acknowledgement of asbestos assessment. Just as a point of reference, in the year 2019, Washoe County Air Quality Management issued 958 AAAs, acknowledgements of asbestos assessment. In 2020, we issued 623 of these documents. And in 2021, to date, we have issued 195. So, did the appellant obtain an asbestos assessment acknowledgement prior to the work at the facility on June 10th, 2019? The answer to that is no. Is this a violation of county and or federal regulations? The answer to that is yes. The next violation that I would like to discuss is...
Can I interrupt for a second?
Yes.
If we have questions regarding each of the various violations, should we discuss that now or just wait till your presentation's over?
We could wait till the presentation's over. What do you think would be the best solution here?
Madam Chair, in the past is usually questions are asked after the presentation. It is at the discretion of the hearing board whether they want to be able to ask Mr. Ristori or Mr. Vega questions during the hearing. It could be whichever is easiest. If you want to jot down questions and ask them at the end, the board can do that at their discretion. Or if they want to interrupt Mr. Ristori during his presentation, they can go ahead and ask him now.
Well, each violation is slightly different, so I don't know. I have to get the consensus from the other board whether they would like to hold all questions or answer them as we go.
Do the board members want to respond?
I think I'd like to, this is Jeannie Rucker speaking. I think I would like to hold my questions until the end.
This is Jim Kenny. I'd like to wait till the end too, please.
Okay. Okay, let's proceed.
Ron, I'd like to wait to the end as well.
All right, let's proceed.
Thank you. So again, the next violation that we'd like to discuss is Aqmv 21-0003. And the violation is for failure to thoroughly inspect the affected facility or part of the facility where the demolition or renovation operation will occur for the presence of asbestos. And I want to be clear that in moving from violation 0002 to 0003, we're moving in regulatory authority. We're moving from local regulations 030107 to 40 CFR 61 subpart M. So pursuant to 40 CFR 61 subpart M, the national emission standard for asbestos 61.145, standards for demolition and renovation applicability state that the appellant, the owner and or operator of the demolition activity, did not thoroughly inspect the affected facility, the Reindeer Lodge, or part of the affected facility, in this case, at the Reindeer Lodge where demolition was to occur for the presence of asbestos prior to the start of demolition or renovation activity on June 10th, 2019. The asbestos survey was conducted by Nova Geotechnical, as previously stated, and inspection services on June 14th, 2019. Again, this was after the Aqmd was notified that demolition had taken place. And I should note that the Aqmd was notified on the 10th that demolition was taking place at the Reindeer Lodge by other demolition contractors in Washoe County and certified asbestos abatement companies in Washoe County inquiring about the demolition activity at the Reindeer Lodge. The survey was conducted after the start of demolition on June 10th, 2019, and it was essentially directed by the Aqmd. The Aqmd provided direction to the appellant to perform an asbestos survey, as well as the other requirements that would be necessary in order to proceed with the demolition. You can see notice of violation number Aqmv 21-0003 attachment 2 on the staff report. That is the survey that was completed by Nova Geotechnical on June 14th, 2019. So some things that I would like to point out at this point in this violation. The appellants will probably try to argue that the Reindeer Lodge is the appellant's primary residence, and therefore subpart M does not apply. And so I want to reiterate and remind the board of the definition of a facility, in that it is a commercial space. The Reindeer Lodge has always been a commercial space. It will continue to be a commercial space, and it is continuing to be zoned commercial. Therefore, there is no there's no caveat in the definition of facility in 40 CFR 61 subpart M that states if it is someone's primary residence that it is exempt or not subject to this subpart. And also the appellant may argue that the work that occurred at the Reindeer Lodge on June 10th was completed to clear an entryway at the facility so that they could gain entrance to the structure to complete an asbestos survey. So during my initial investigation and subsequent meetings with the appellant and his consultants, it was identified that there were easily accessible doors, windows, and access points to the structure that did not require demolition of the structure. I would also like to point out a photograph of the Reindeer Lodge on June 9th, 2019, taken from a news article. I think we can all agree that the amount of disturbance in this photograph far exceeds what would be necessary to gain access to the structure. And let me see here. can everyone see this photograph?
Yeah, got it.
Yes, I can see it.
So this is a photograph that was, again, taken from a news article on June 9th, 2019, demonstrating the disturbance or demolition, I will call it, at the Reindeer Lodge. This is the same activity that I had observed when I drove up to the lodge on June 10th, 2019. Okay, just to confirm, everyone's back to the PowerPoint presentation.
Yes.
Okay. So,
Yeah.
did the appellant have an asbestos survey completed prior to the work at the facility on June 10th, 2019? The answer to that is no. And is this a violation of county and/or federal regulations? Yes, this is a violation of federal regulations. Next, I'd like to discuss Aqmv 21-0004. This is for failure to provide the Aqmd with a written notice of intention to demolish or renovate 10 days prior to the start of the demolition or renovation of the Reindeer Lodge as required by 40 CFR 61, Subpart 61.145A1. So pursuant to this section, the appellant, the owner or operator of the demolition and renovation activity, failed to provide an asbestos NESHAP notification of demolition or renovation at least 10 working days prior to the start of demolition. A complete asbestos NESHAP notification of demolition was submitted and fees satisfied on September 14th, 2020. The notification was submitted in the spirit of compromise and cooperation, but under duress and protest. This language was associated with a document provided by the appellant's attorney when they submitted the form. So again, they were not submitting this notification to us while agreeing to comply with the rule. They were submitting it under duress and under protest. And you can see that document as attachment 4 under Aqmv 21-0004. And I want to point out the majority of the main structure at the Reindeer Lodge was demolished by the time the NESHAP notification of demolition was submitted on September 14th, 2020. And I would like to share with everyone another document to demonstrate that point. So in June of 2020, the Washoe County Building Department was potentially going to move forward with requiring the demolition of the structure at the Reindeer Lodge. And here we can see a picture of the Reindeer Lodge in good condition prior to the roof collapse. This is post-roof collapse. Again, a close-up of the post-roof collapse. This is June 12th of 2020. This indicates to us this is a complete demolition. Well, not a complete demolition, but the majority of the structure has been demolished at this point. And again, I want to point out that we did not receive an NESHAP notification of demolition for this structure until September 14th, 2020. And here's another photograph from the same date, different perspective. And another photograph, different perspective. So the question is, did the appellant submit a NESHAP notification of demolition and renovation prior to the work at the facility on June 10th, 2019? The answer to that is no. Is this a violation of county and or federal regulations? The answer is yes. And the last violation we'd like to discuss is Aqmv 21-0005. And this states failure to remove all rackham from a facility being demolished or renovated before any activity begins that would break up, dislodge, or similarly disturb the material or preclude access to the material for subsequent removal. So pursuant to 40 CFR 61 Subpart M, procedures for asbestos emission control, the appellant, the owner and operator of the demolition activity, failed to remove all regulated asbestos containing material. Again, category 2 non-friable transite siding was found in the what we're calling the demolition or debris pile in that northeast corner identified on June 10th, 2019. And they failed to, so therefore they failed to remove that material prior to that disturbance. Sections of transite paneling were crumbled, pulverized, and reduced to a powder due to forces acted upon the panels during the course of the demolition and renovation activity that occurred on or before June 10th, 2019. So see the attachment number 1 of the staff report for those photos.
Slipped off, right.
The exterior of the building was clearly accessible for inspection and asbestos sampling prior to the demolition and or renovation activity on or before June 10th, 2019. And it's at this point I'd like to point out some other points in regards to these violations. So the appellant may argue that the Aqmd did not know the amount of asbestos that was present in the at the Reindeer Lodge to trigger a notification requirement or to trigger removal of this material. And as noted in the abatement notification that was provided to us in September of 2019 from the abatement contractor that Gary Schmidt hired, or the appellant hired, approximately 420 square feet of spray acoustic ceiling, which is friable ACM, was identified, and approximately 3,180 square feet of transite paneling was found associated with the outside of that structure. Also, there was 27 cubic yards estimated as the debris pile, contaminated asbestos debris pile associated with that original demolition on or before June 10th, 2019. And also you may again hear that the appellant is going to argue that the Aqmd is using selective enforcement in regards to requiring them to provide a NESHAP notification to the Aqmd prior to the start of demolition. In 2019, the Aqmd issued 114 demolition permits. In 2020, the Aqmd issued 79 demolition permits, and to date, 2021, the Aqmd has issued 23 NESHAP notifications of demolition. So did the appellant have a regulated asbestos containing material removed prior to the work at the facility on June 10th? The answer to that is no. And is this a violation of county and or federal regulations? The answer to that is yes. And with that, I will entertain any questions you may have.
Okay, we're now open for questions from the board for staff.
Mr. Ristori, could you please tell me what RACM stands for?
Absolutely. If you don't mind, I'll move back in the slides so that we can have it up in front of us. So the definition, according to 40 CFR 61 Subpart M, regulated asbestos containing material, friable material, category 1 non-friable that has become friable, which is category 1 non-friable that also will be subject to sanding, grinding, cutting, or abrading, or category 2 non-friable that has a high probability of becoming or has been crumbled, pulverized, or reduced to a powder by the forces expected to act on the material in the course of demolition, renovation operations regulated by this subpart.
Good, thank you. A second question I have, is it general knowledge among licensed contractors that an evaluation of asbestos needs to be undertaken prior to demolition? The question really goes to whether Mr. Schmidt would know of these requirements, or is his knowledge imputed to the contractor undertaking the demolition?
I would rely on, as far as Mr. Schmidt's knowledge, I would rely on him to testify in regards to that. But from what I understand with the process of any building permits issued for commercial construction or demolition, a licensed contractor has to be hired in order to perform those activities on a commercial structure. The only areas where someone can actually do the work themselves is typically if you are a homeowner and you're performing that work on your own home, is my understanding. With that, again, I'm not a general contractor, but my understanding with a general contractor's license is there is some information or requirements in the testing to become a general contractor that requires you to be aware of asbestos and other environmental hazards associated with construction activities.
And who was the general contractor who undertook the demolition?
My understanding is that the, and I don't have a copy of that building permit, but my understanding, speaking with Mr. Schmidt on June 10th, 2019, was that Mr. Schmidt obtained Collins Construction, I believe, as a contractor to assist in the work that was being performed at the Reindeer Lodge.
Okay, thank you.
Mr. Harris, I'd also like to add that the requirements and regulations surrounding the abatement and control of asbestos have been around for over 40 years. And as Mr. Ristori explained, that we receive a number of these on an annual basis that are able to be complied with. So again, the regulations and requirements are extremely well established. And so I just wanted to state that.
Mr. Ristori, the documentation that I received only showed a limited asbestos survey. A limited asbestos survey is not the same as a renovation asbestos survey or a demolition survey. Was an actual renovation or demo survey provided?
No. The limited asbestos survey was conducted, and I believe it was conducted because of the condition of the building and only having a limited access based on the condition of the building and the safety of assessing the building. I believe that's why they titled it a limited asbestos survey.
I've got a question for you. The Eagle, what is it called? All Eagle LLC filled out an AAA that said that there was, 27 cubic feet of mixed debris and 200 square feet of acoustic ceiling and 3,180 square feet of transite. Yet when later documentation for the EPA NESHAP notice of demolition and renovation showed, the first form showed 200 square feet and the second form showed 20 cubic feet. Do you know why there was such a difference in the amount of asbestos?
I'm not sure. Well, so the notification, and I think you're speaking more to the NESHAP notification of demolition and abatement.
Correct.
So the notification that was submitted by All Eagle was to conduct the abatement of the materials that were determined to contain asbestos. So in their notification, they were identifying, as required, the materials that were to be removed during their abatement process. And I believe you're comparing that to the document that was submitted by the appellant in September of 2020.
Yes,
And it was, the understanding was that there was still going to be transite material within that structure. And therefore that material would need to be, or the demolition would need to take place in a very careful manner in order to remove it intact. And I believe that's the reasoning that that number was indicated on that NESHAP notification.
so I guess I'm a little confused because I know the appellant is going to say that the amount of asbestos was less than 35 cubic feet and therefore it didn't fall under the regulations.
Ultimately, any demolition activity falls under the regulations. So even after a facility goes through an abatement, because essentially the structure fell below those thresholds because an abatement occurred. That's the process. Is we find a facility that's going to go through a renovation or demolition. They survey it for asbestos. The asbestos is then removed to the best extent possible. Typically, it's in a structure that's not in this condition. And then they submit a subsequent demolition notification indicating that they're going to demolish that structure. That's our process for every demolition activity that happens in Washoe County where a building or a structure is going to be demolished that's been deemed a facility by definition.
Okay, so All Eagle LLC took off more than 35 cubic feet or say 3,000 square feet of asbestos material to Lockwood landfill.
Yes, and I think it's important to point out, I think you're referring to the 35 cubic feet potentially based on the appellant's documentation that was submitted today.
Yeah,
And there's other thresholds in the NESHAP, in 40 CFR 61 Subpart M that apply. In that same paragraph that references the 35 cubic feet, it also states any facility where it's been determined that asbestos containing material in excess of 260 linear feet, 160 square feet, and 35 cubic feet is required to go through an abatement and have a demolition notification submitted to the air district that has been delegated authority for that subpart. So there is some language, I believe, missing from their argument there.
okay. And was there a waste manifest submitted to Lockwood landfill that would tell exactly the amount of asbestos material that was sent to the landfill?
We have waste manifests from the abatement contractor, have nothing from the appellant.
And that manifest shows more than 35 cubic feet or however many linear feet was removed from the site.
Yes, I believe they estimated in cubic feet or maybe even yards in those cases, because as those dumpsters are filled or as those trucks are filled and taken to the landfill, that's how the landfill is going to accept it, is in volume. They're not going to count the number of square feet that's associated with that dumpster or that truck that's bringing the material to them.
And so the amount of material present and removed was greater than the minimum amount triggered by the regulation.
Absolutely, correct.
I have a few questions. The first, this is Jeannie Rucker. The first was relating to that initial building permit, the one issued in April of 2018. It's my understanding that a lot of the building plans are routed through various county agencies for review. Did air quality ever see that application and review it?
Not to my knowledge.
Okay, and then there was another remodel renovation permit. Purportedly, this was according to Mr. Taylor's August 2020 letter. There was another remodel renovation permit in February of 2019. Was that reviewed by air quality?
And not to my knowledge.
Okay. Let's see, some of the questions I had previously from looking through my packet were answered. In the NOVA geotechnical report, the sample location map provided a demo line, which really only outlined that northeast section of the building. And yet samples were taken in the rest of the building. And my question was, if the rest of the building was to be left intact, why did they need samples? Or was there other construction activity already planned? So based on your pictures, it looks like there was other demolition planned, but at the time that the survey was done, the sample survey, what were the plans?
My understanding was that the plan was to remove, like the building permit that I presented was to remove the damaged portion of the building. And I believe that's why those samples were taken in other areas of the structure. For instance, there was a kitchen or dining area where the roof had completely collapsed in that contained the acoustic ceiling or the spray acoustic ceiling that contained asbestos. That area was cleaned up so that they could remove that portion of the building. I believe, or the Air Quality Management Division believes, that the intention of the appellant was to demolish the building as you saw in the photographs in June of 2020.
Okay. A couple more questions. I just noted that the appellant had grossly underestimated the volume of the RICM material that needed to be removed. The violations occurred in June of 2019. And there's, I've read my packet thoroughly, and I wish there had been a chronology included, which would have made it a little bit easier for me to follow the path. But why was the NOV not issued until February of this year? Or
That's a
all
great.
NOVs, I should say.
The notice of violation was not issued at that time because we were working with Gary Schmidt to move forward. We were working with CSD to move forward to get this building and this area cleaned up. There was hesitation that if we issued a notice of violation at that time, it would stall the process even further. At no point in any of my conversations with the appellant did I ever indicate that we would not be issuing a notice of violation. In fact, at just about every meeting that I had with the appellant and his consultants at the Reindeer Lodge, I made it very clear that there were violations of local rules and federal rules, and that we would potentially be moving forward with notices of violation to the appellant. Ultimately, the decision was made to not issue those violations until we finally got compliance. Ultimately, we never really got compliance with the notification requirement for demolition. The building was completely down in June of 2020. We didn't receive that notification until September of 2020. Typically with environmental rules, you work at getting the regulated community in compliance, and then you essentially backdate how long have they been out of compliance to issue that penalty or to issue the violation, and then understand what the penalty may be. So that is the reasoning that I could provide for the delay in issuance of the notice of violation.
Okay, I can appreciate that. One last, it's more of a comment than a question. I read the appeal that was included in the staff packet, which to me was extremely vague. There was reference to NRS 278, which is planning and zoning, and I found nowhere in 278 where it was actually relative to this issue. But the other comment that I have is, as I prepared to come online tonight to attend this meeting, that's when I received a document from Mr. Schmidt, and apparently also a document from his attorney with a variety of statements, none of which I have had time to review. So I've, you know, it's just a comment at this point that I may be hesitant to make a decision tonight based on the fact that I've only seen the very vague appeal that was attached to the staff report, and what was in the staff report plus your presentation. I'm to understand that the attorney for Mr. Schmidt is also to make a presentation.
Yeah, yes, he will follow as soon as we're done with our discussion.
Okay, all right, thank you.
Thank you.
Okay, so I have a question. Can everybody hear me?
Yes.
Yeah, okay. So from my understanding and everything that I had very little time to read, but from what I'm listening, basically, there has been no compliance with the rules as they are stated.
I will say there has been some compliance. We are focusing on the initial non-compliance incident that happened on or before June 10th, 2019.
Okay, I just wanted to be clear on that, because if there's an obvious case of non-compliance, then personally, I'm not really seeing where there's a question.
Understood.
This is
Any
Kenny.
other
I have one other
questions?
question,
Go ahead.
and this refers to the letter from Gary Schmidt. I think Gene was just referring to, and he makes a statement in 11A saying, as previously noted, no demolition as defined by regulations occurred prior to September 12th, 2019, and then it was commenced by all legal construction. Would you say that is an accurate statement?
I would not say that's an accurate statement. I would say that my observations on June 10th and my experience with this position in observing demolition activity, the result of what I saw in the northeast corner of the Reindeer Lodge constituted demolition as defined by 40 CFR 61 Subpart M.
And were there two permits for renovation exploration issued by the building department, one on February 26, 2019, the other one in 2018 on 4/6? Is that true?
The only building permit that I am familiar with, which we've stated in our case, is the WBLD 18-105119.
And that was 4/6/2018. Because Mr. Schmidt in his letter, he references one February 26, 2019. So I just want to clarify there were two issued. Just trying.
And I'm not familiar with that building permit.
I actually looked online today at the Washoe County permit, where you can go back and check all of the previous permits, and I could not find anything for that date.
So the only one we'll confirm is 2018 on April 6th. Okay, thank you. That's all my questions.
Just one final question. What's the status of the Reindeer Lodge today? Is it partially demolished, fully demolished, still part of it standing?
The last observation that I had was a few weeks ago. It is partially demolished. I believe the intent of the appellant is to keep a portion of the structure such that it can be rebuilt. It's an apartment that was off on the west side of the structure, such that they could rebuild or remodel to make it habitable, so someone could live inside that structure. So I would say at this point, it's partially demolished.
So that particular part of that structure was really the only part of it that wasn't damaged in the collapse, right?
I believe so, yes. I believe that's a correct statement.
Because over the last couple of years, there has been continuous work on that site, because I drive up and down that mountain at least once a month.
Are there any other questions? Are there any other questions from the board?
Mr. Story, I've got one last question. Did you ever receive a signed copy of the survey?
I did. We received a copy of the survey, I believe, on, I want to say July 2nd of 2019.
Thank you.
I'm sorry, July 5th of 2019 is when we received our copy, and it was sent electronically.
Thank you.
I'd like to make a clarification if I could. It is common knowledge for every general that I have come in contact with, it is required to get an asbestos survey, not only to get a permit, but before you commence any work. So I don't know how that is even in question. My real question is looking at the pictures of the facility and the damage that was incurred by the snow and the safety issues for going in to inspect. I understand that that would be a real issue. I certainly wouldn't want to get near that facility. But it's my understanding in a situation like that, where there is a compromised structure, that in that event, you have to take the pretense that there are potential issues of asbestos, and you have to treat it as such until you have the building to a situation where you can actually go in and take out materials to get them inspected. So there's a little bit of leadway in that, but you still have to take all the necessary precautions. Now, as Mr. Ristori had said, that if it's a private residence and a homeowner wants to take that upon themselves, they certainly can. But as a contractor, you certainly would not want to put yourself in that type of liability. And it's a major liability to put not only a homeowner and its family, their family, but also a commercial type of project where you might have the public involved. So I think it's important that everybody understands that when you get involved in these types of demos, you have to look at the public safety first before, and that would include the workers. The people that are working on the demo are also going to be exposed. So it's very important that as soon as possible, you get whatever materials tested. And I did read the letter here from Mr. Jepson, and I did have the privilege of meeting Mr. Jepson. And his credentials are substantial. And what they have to say and what Mr. Pezzanella had to say, and I have had Mr. Pezzanella work for me also. So they have some very important literature here, I think, that everybody needs to read. But that doesn't excuse, I don't want to go back and forth. I'm not trying to go back and forth, but every general knows, and I make sure I tell all my clients up front, we will not do anything until we have that survey. And if they're not willing to do that, then we just don't do the job. I hope that helps.
That helped me, but also, wouldn't there also be an understanding on the part of the contractor before they would take on a job like that, a recognition that a building of that age would very obviously contain asbestos-containing materials?
So my experience is that we have everything tested. It doesn't matter if it happened a week ago. We just simply have it tested. The risk is not worth it. It just simply is not worth it. And so I can't speak for other people, but that's how we operate. I think last time I dealt with any type of issues would be whether the demolition was less than 9 square feet. So that's a 3x3 area, and that's total. So for example, if you were to cut out a door, that would be both sides of the wall, and that would exceed the 9 square feet. So we just get it done. I mean, it's just how it works.
Madam Chair, This is
What-
Brian City for the record. There'll be a time and point for the board to add in discussion. This is, I think we've moved away from questioning into discussion. There'll be a time for the board to make such discussions that are occurring right now between each other.
Okay,
Okay, I appreciate your comment. If there are no further questions regarding information provided by staff, we will move on to hear from the appellant.
Madam Chair,
Yes,
if I may, I'd like the opportunity to kind of address Ms. Rucker's concerns in regards to timeliness, if that's appropriate.
that is. Go ahead.
Thank you. I just wanted to say that we agree that, we were concerned in regards to the untimely availability of the information provided by the appellant. And the only thing I wanted to add is that the appellant has had the information associated with the violations since December. The original appeal hearing was scheduled for March 2nd. At the request of the appellant, the appeal hearing was rescheduled for April 6th. In a certified letter to the appellant and his representation notifying them of the April 6th appeal hearing, it was stated that if they wish to waive their right to a hearing within 60 days from the filing of the appeals and request a continuance, they could submit a written request by March 26th. We never received any kind of request for a continuance or extension or anything like that. So again, we provided that opportunity for a continuance, and again, we just never received that information. So that's why we prepared for today's meeting, and I'm hoping we're able to come to some kind of conclusion. Thank you.
At this time, then, we are ready to hear the case from the appellant.
Yes, hello, Madam Chair, board members. This is Taylor Jenkins. I am appearing on behalf of Mr. Schmidt. Let me start my video here. I apologize. I'd like to start off with a couple of comments on the department's testimony. Number one, I promise I will not use too many big fancy words. I'm gonna keep it as simple as possible. Another thing that I took away from their testimony was opinions. I heard a whole kit and caboodle of opinions about what the appellant was going to argue, what had happened up at the Reindeer Lodge. One of the things I noticed we were missing was any actual proof. We have a supposition that work was being performed. I don't have any proof that any work was performed whatsoever up there, and I do not believe the department can provide that. I don't see any pictures showing the property being more or less disturbed from the date of the proposed violations, June 10, 2019. I don't see any pictures of actual work being performed. I don't see machinery moving anything. I would also like to point out that the square footage on the ceilings and on the walls and sidings. So it is our contention, having been in the facility, or more directly Mr. Schmidt's contention, that some 80% of the ceiling had been previously replaced with drywall and other materials. In regards to the measurement of the siding, that would be the entire perimeter of the building, not taking into account any doors or windows or other openings. I also heard about all of the things that air quality management has issued, permits, notices, but what I didn't hear about were violations. We were not told how many violations were issued in 2019, 2020, or 2021. I will get into that a little further. Let me start by saying, now that I've addressed those issues, that I appreciate the opportunity to speak tonight. I want to thank everyone for staying late. It's 7 o'clock on a Friday, which is a load of fun for all of us. I have some general grounds for dismissal of all of the notices. And the first one has been alluded to, which is the 19-month disparity between the alleged date of the infraction or violation and the actual issuance of the violation. It is our contention that Mr. Schmidt complied during the time this project was undergoing. And I think we heard testimony that the violations were not issued as a perhaps a carrot to keep Mr. Schmidt moving along. But once you gain compliance, what is the point of issuing the violation post facto? It is our contention that AQDM has no right to issue those citations at that time. We would also like to point out that we have made, I'm going to suggest 5 public records requests of Washoe County Air Quality Management. Those 5 requests have never been answered. We have received the cursory email from Mr. Vega that the requests were received, but no further communication. Now, pursuant to NRS 239-0107, a public information request is required by law to be answered within 5 days. In that first response, there can be essentially 3 outcomes. The first being, here's your information. The second being, the information you've asked for is privileged or somehow classified and unavailable to you. The third answer is a date with which we might expect to have the information delivered. I will draw your attention to, I'm gonna call it Appellant's Exhibit E, which is a lawsuit filed by Mr. Schmidt against Washoe County Air Management Department. Also does name Mr. Vega, but in his capacity as the director. We have all of those emails are there to be seen in Exhibits 1 through 5. Additionally, on January 11, 2021, Air Quality Management held a compliance and enforcement meeting attended by myself in Mr. Schmidt's place with the stated purpose to discuss supporting information associated with the draft notices of violation and for Gary Schmidt to present evidence to contest the findings associated with the draft notice of violations. I was afforded no opportunity to have a meaningful dialogue to address my concerns, nor was I provided any evidence of the violations by the department. I would like to circle back for one moment to my public records request. One of our requests was for the entire file of Mr. Schmidt. And one of the pieces of information which the department was able to reference, but I am not, is the waste manifest from Lockwood, for example. We have received nothing. In my opinion, that in and of itself is grounds for dismissal, but I shall move on. Assuming that the board does not wish to rule on any of my first 3 causes for dismissal, I will move on into specific arguments.
Yes, go ahead and proceed.
Okay. In regards to AQM V21-0002, Mr. Schmidt applied for and received a building permit on February 26, 2019 from the Washoe County Building Department. The violation, if I recall correctly, suggests that the issuance of the violation, or the issuance of the permit is the subject of the violation. And I would ask the question, has the building department been subsequently also fined for issuing said permit? The remainder of my arguments or points of order will apply generally to all of the violations. 0002 through 0005. And not to disappoint Mr. Ristori, I am going to argue that the Reindeer Lodge was not a facility and thus not subject to the 40 CFR. In addition, the project did not meet the threshold for hazardous materials to make it subject to regulation. The threshold, as we have discussed, is 1 cubic meter or 35.3147 cubic feet. Pursuant to the NESAP form, which was received and accepted by Air Quality Management, or Aqmd, on September 14, 2020, less than 20 cubic feet of material were present at the Reindeer Lodge. I want to point out that they accepted the NESAP form. The third exemption, if you will, to the CFR is that the project was an emergency undertaking due to the collapse of the roof. I think that it's relatively undisputed that the roof collapsed due to heavy snows in the winter of 16 and 17. The condition of the structure deteriorated over 2 subsequent winters, and the state of the property was a source of potential liability for both Mr. Schmidt and the county. My next point is Aqmd issued a permit. That number is ASB 19-0963 on September 12, 2019. That is in the staff report on page 13. Again, a true and correct copy, or true and correct signed copy of the NESAP form was stamped received by AQDM on September 14, 2020. Again, showing less than 20 cubic feet of material being removed. That document for reference is on page 90 of the staff report. Aqmd admits this document was received and approved on September 14. That's on page 70. This shows by action of Aqmd themselves that the NESAP was not required. They're accepting that the amount of material falls below the thresholds. My next point is that prior to September 12, 2019, no demolition had occurred on the structure or moving of the natural debris pile, with the exception of the removal of several exposed collapsed beams. I don't think it can be disputed that the beams were no longer structural in nature, and the beams were moved to an area adjacent to the debris pile to be potentially used for later renovation, potentially. In my exhibit A, which is Gary Schmidt's statement, and my exhibit B, which is Ray Pezzanella's statement, they both state the same thing. So we assert that Washoe County is not in compliance with state law and or county codes in regards to the appointment and authorization of a building official as defined and mandated by said laws and codes, as well as the establishing of a continuing education requirements which would be designated by said building official. You can see that in my exhibits C and D, which are letters from Don Jepson, who, as far as we know, was the last appointed building official in Washoe County who has been has not been in that position since 2017. For reference, that'll be NRS 278, which authorizes the creation of a building official in the county with between 1 and 700,000 people. I'm not going to quote the whole law to you. And then in addition, Washoe County Code Chapter 100, which authorizes the creation of the building department as well as the creation of that position.
Mr. Jenkins, if I could interrupt for a second, we're trying to keep on point and discuss specifically the asbestos violations. So anything related to Washoe County Building Department is not really relevant to our discussion.
Well, if you'll give me a little leeway here, the relevance is that the building inspector, that position defines who can actually inspect a building, which leads me into my next point. We assert that Joshua Ristori has no authority to inspect a building as to the soundness of the structure or related issues, again, due to the lack of the building official. Again, the building official is allowed to appoint who may or may not inspect structures, as well as set the continuing education requirements, which it's our assertion that by not having that position, the county and then hence Air Quality Management Division for conducting an inspection has violated the law. My next point is a statement from, I apologize. My last statement about Mr. Ristori and his authority or lack thereof can be found again in Exhibit D, which is a letter from Don Jepson and Washoe County Code, Chapter 100. I have some essentially statements from Mr. Schmidt that I'm going to read now and offer. At all times, Mr. Schmidt attempted to cooperate fully with any and all agencies of the county, and at all times acted in good faith. Mr. Schmidt and his associates were assured that no action would be taken as long as the project was conducted in compliance with all regulations. Again, see Exhibit A and Exhibit B, Schmidt and Pezzanella's statements. Specifically, Mr. Schmidt and his associates relied upon assurances of Mike Wolf, then the supervisor of inspection, that there would be no action taken based upon allegedly early activities on the site, so long as the project was quickly completed to the satisfaction of Aqmd. Mr. Wolf also noted that neighbors in the area had complained as to the state of the Reindeer Lodge, and the county wanted the project completed quickly. Again, see Exhibit B, which is a statement from Ray Pezzanella. Mr. Schmidt insists that the county at all times has acted with malice aforethought, prejudice, animosity, hostility, and in an arbitrary and capricious manner against Mr. Schmidt and his project at the Reindeer Lodge. Due to the stress, Mr. Schmidt has suffered deteriorating medical conditions, largely associated with the stress of this project. Mr. Schmidt has complied completely with all requests and demands of the county, even though he was not required to do so. As yet, Aqmd, notice of violations were issued once complete compliance had been acquired, which shows the arbitrary and capricious nature of the actions of Aqmd against him. Thank you. That concludes my presentation, if you will.
Okay, members of the board, do we have questions for Mr. Jenkins?
I do have a question for Mr. Jenkins. Mr. Jenkins, you talked about some of the ceiling was replaced with drywall. Is that correct?
That is correct. I am told by Mr. Schmidt that approximately 80% of the ceiling had been replaced. Additionally,
do you know what
Mr.
year that was?
I'm going to say that is over the life of his ownership, which started in 1971, as Mr. Ristori pointed out.
And do you
So
have
he's
any
owned the property for
receipts or contractors invoices from that work completed?
I do not have any with me in the packet I have. No, sir.
Okay, thank you. Yeah, the other question is, there's kind of a discrepancy in when the renovation exploration permit was issued, and you said February 26, 2019. Do you have a copy of that?
I do not. I believe, in fact, that the correct date is 2018. I believe my notes were wrong. I apologize.
So can you confirm what date that was issued then?
Oh, I believe it is 2019. I believe my date was right.
So just for the record, can you confirm which date the renovation and exploration permit was issued?
Which, I'm sorry, say again, state or date?
What date? Yes, correct.
Pardon me one second. I'm referring back to my notes so I don't misspeak. My notes say February 26, 2019.
But you have no copy of that permit.
I do not have a copy of the permit. I do not, sir.
very much.
Okay, Mr. Jenkins, I actually searched on the Washoe County building permits website, and there are no permits issued for that date for the Reindeer Lodge. So the only permit that we have for renovation is the one from 2018 that the Aqmd told us about earlier. Do you have anything else that would prove that there's another permit on that in 2019?
So let me be very clear. So my notes may be incorrect as to the date, but we are not asserting that there are two. We are asserting there is only one.
Okay, thank you.
You're welcome.
And I guess I have another question with regard to a building inspector. So Mr. Ristori is not following duties as a building inspector. He's an air quality management district supervisor that goes out and determines whether people are complying with the Aqmd regulations. So I'm just not sure exactly what all of the letters regarding building inspectors relates to for this case.
So it is the opinion of the appellant, or our opinion, that Mr. Ristori made several determinations as to the state of the structure and how that state of the structure makes it apply to the CFR. So for instance, he said it was demolished. He said it was unsound, it was unfit. He made several determinations in his own testimony, which necessarily implied that he was inspecting and then making a judgment about, again, the fitness or soundness of the structure.
My question is that when you look at the permit, the AAA issued by All Eagle LLC, it specifies that it's a demolition project. So how is that different?
Now, how is that different? They are not a government employee making a determination. I understand your question, or let me rephrase. If I may ask a question to clarify your question, are you asking if it's possible that Mr. Ristori got that information from the All Eagle permit?
Well, it just appears that if there's equipment and excavators that are tearing down a building, that would be considered demolition by anyone who observes that. And it's apparent that All Eagle LLC reached the same conclusion when they were doing the work.
So the demolition was used as an example. It is our contention that he is investigating a structure, which he is unallowed to do. I understand what you're saying, and my counterpoint would be All Eagle Construction is not a governmental employee, hence not paid by the county to do an inspection of a building. They're a private contractor who their opinion of what's going on is not regulated by said building official. Additionally, it could be argued that there was some demolition, some renovation, but that point seems somewhat superfluous at this moment.
Yeah, I guess I would make a distinction between a building inspector and someone from Aqmd who's observing activities and whether it complies with the asbestos regulations.
Okay.
Are there other questions from the board for Mr. Jenkins?
I have a question.
Yes,
Mr.
sir.
Jenkins, I'm looking at this letter from Ray Pezzanella. And it says, and this is Pezzanella saying this, to my knowledge, all demolition work at the Reindeer Lodge was monitored and supervised by Josh Ristori of Air Quality Management Division and Tom Weiss, an independent consultant from Weiss Consulting and Training. So if Mr. Weiss was on the job, is that what I'm hearing? He was there during the demolition process?
So he was there for large portions of the project, specifically where there might be any potential issues that the county might want to regulate. He was there for large chunks of the project.
Mr. Weiss did not provide any asbestos of any kind, any testing?
I am unclear as to that. I believe his consulting was to supervise the proper removal and handling of any asbestos found. I do not believe he provided any testing.
And you say that Mr. Ristori was also there supervising?
Mr. Ristori was
Say
there.
that.
He said that in my recollection of his testimony, I'm sorry, we're getting overlapped, so I'm not trying to cut you off, sir. In my recollection of his testimony, he said he was there on many occasions. I can't even count how many he said he was up there. And so that's Mr. Pezzanello's written statement, and it's not mine. If Mr. Pezzanello says he saw Mr. Ristori at the Reindeer Lodge supervising work or directing what might need to be done, I would have to take Mr. Pezzanello at his word.
Are there any other questions from the board for Mr. Jenkins?
I do have one further comment. The copy of the building permit, which was issued on February, never mind. I apologize.
Madam Chair, if I may.
Yes, go ahead.
Okay, I'd like to address one of Mr. Jenkins' comments, and this is in regards to our issuance of the violations. I think what he termed as after compliance had been achieved, and that our actions are punitive, and I don't want to use his, I'm paraphrasing, obviously, I'm not using his exact words, but are punitive and vindictive. But again, the penalties levied by the Aqmd act as a deterrent against future non-compliance from not just a violator, but others in the regulated community. In fact, the principle of deterrence has been behind the US EPA's compliance monitoring and enforcement program since the beginning. And I'd like to give you a good example. A good example is a speeding ticket. When an individual gets pulled over for speeding, why does the officer issue a ticket with a fine? The officer has achieved compliance by pulling you over. Why bother issuing a ticket at that point? The reason is that it acts as a deterrent to you speeding in the future. This is the same with the violations and penalties issued by the Aqmd. We want to make sure we protect the health of the public by deterring violators from similar action in the future.
Madam Chair, if I might respond to that, and I don't want to get into an argument with Mr. Vega, but I would like to make a point, and I think he made it for me. So the police officer pulls you over when you're speeding. He gives you the ticket right then. You don't go home, have dinner, wait 6 months, and then you get the ticket. You got the ticket at the occurrence of the event, and that is our point exactly. Thank you very much.
No further questions for Mr. Jenkins? Okay. We will
Madam Chair, may I comment on both Mr. Jenkins and Mr. Vega's comments?
Yes, go ahead.
So I think it's important to realize here that if we're considering compliance with the notification requirement for demolition September of 2020, compliance was not met until almost a year and a half after the initial demolition occurred. again, I really want to bring the board back to focusing on the original demolition that occurred on or before June 10th, 2019. And even when the notification was submitted to the Air District, it was submitted under protest and duress, meaning that they still don't feel, even to this day, that that facility is regulated under 40 CFR Part 61 Subpart M. So in the example of the speeding ticket, yes, compliance was met. Ticket was achieved, or ticket was provided. In this case, compliance hadn't been met maybe ever, because they demolished the majority, I'll call it, of the building in the summer of 2020 without a notification. And I also want to point out that it's very incorrect to presume that a structure that's deemed a facility does not require notification prior to demolition, because in 40 CFR Part 61, 61-145, it does state in a facility being demolished, only the notification requirements of paragraphs X, Y, and Z of this section apply if the combined amount of Rackham is less than 260 square feet or 260 linear feet, 160 square feet, or less than 35 cubic feet, meaning that a notification is still required on the demolition of a facility. So therefore, this issue here of deciding whether or not they were in compliance goes back to the date of June 10th, 2019. Did they submit a notification? No. And then they did demolish the building. They continued to demolish the building after the abatement occurred, which is a good thing because the majority of the asbestos was gone. But then they continued to demolish the building the summer of 2020. And then after the building was on the ground, they submit the notification. And I'll conclude my comments there.
Madam Chairman, can I ask Mr. Ristori a question?
Yes, go ahead.
Mr. Ristori, they have asserted that you acted in the capacity of a building official. And they've indicated
Point of order. A building inspector, ma'am. A building inspector, not a building official.
Okay, building inspector. You were on site frequently at that site, is that correct?
I would not define it as frequently.
Okay. At any time, were there other building inspectors there to speak to the stability or the, the actual safety in terms of occupancy of that building, to your knowledge?
We're talking government building inspectors?
Yes.
Not to my knowledge.
Okay. And at any time, did you speak to any issue other than the air quality issues related to that site?
I did not.
Thank you.
Okay, if there are no further questions for Mr. Jenkins or the appellate, we will go ahead and close the testimony, and it's now would be open to discussion by the board. So as a board, we may discuss the issues that you've had, and we can have, there are several different findings. We can move to deny the appeal of the 4 violations associated with case number 1229 and administer $36,500 fine. Alternatively, we can move to dismiss case 1229, or we can move to uphold case number 1229 and levy a fine in the amount of $0 to $10,000 per day per violation. So we're open for discussion. Would anyone like to speak regarding this issue?
Yes, ma'am, I would like to speak. This is Yvonne Downs. I am a certified building asbestos inspector. And I can tell you that the laws and regulations say that even if you have 4 private homes that are not necessarily connected to one another, that is considered a facility. These are individual homes that belong to one person. That would be considered a facility. So we have a structure here that has been used as a bar, as rental units that exceed 4 home units. It is considered a facility in accordance with the regulations. I am of the opinion that we move forward with the $36,500 fine as stated. The regulations for me as a certified asbestos building inspector are very, very clear. They have been violated, and the county has bent over backwards trying to help this company come into compliance. And it sounds like the company has also tried to come into compliance too. And as Mr. Ristori and the documentation shows, that the appellate has done all of this under duress, meaning that in my mind, they disagree with all of these regulations in the first place. And from my perspective, they're off base.
Okay, we can put that in the form of a motion, but first I want to make sure that everyone else on the board has the opportunity to speak and give their opinions as needed.
I do have one more question. This is Lee Squire. I'm curious about the maximum occupancy to make a structure facility. Does that have any bearing on it?
According to the regulations, it does not.
Interesting.
As long as it's a commercial use or has been commercial use in the past, it is considered, falls under the asbestos regulations.
Wasn't the Reindeer Lodge considered a commercial use?
Yes, it was.
Okay, then I'm not really getting the question.
I'm sorry. Your question was, is there a square footage that makes it considered to be fall under the regulations?
No, you answered my question for the simple fact that if it was used for commercial use, and if it's used for commercial use, that makes it a facility, then I don't really see where there's a misunderstanding.
Okay, thanks for that clarification. Does anyone else have anything that they would like to add?
I do. I'm just reading this from Mr. Jepson, and there's just a lot of conflicting information here. I think that there needs to be, I think the board needs to read what he had to say. His what's the word I want to use here? His credentials are, I mean, impeccable. I think we need to look at this, seriously look at this. I'm not questioning whether it's a facility or not, or commercial building. I'm really concerned with the fact that we have a building permit, or we don't have a building permit. How did that even come about? I mean, where is this permit from February 26th? I mean, where is it? And if it did happen, how did it happen without any type of asbestos test to it? It's just not possible. I think everybody needs to at least take a minute or two to look at what is said here. I'm not necessarily defending. I just think that we need to look at it. There's some interesting points here. I don't know how All Eagle, I don't know I'm not sure what they're doing in this. Are they consultants? Did they do the demo? I'm not too sure. And then finally, I'd like to know, just serious, I want to know really who has suffered. What is the reasonable damage that has happened, and to whom? That's what I really think this needs to be considered. What is the reasonable damage and to whom?
I'm not sure exactly what you mean by the reasonable damage. Are you saying that you think the fine is onerous?
I think that there's a lot of conflicting information, especially with Mr. Ristori and what he's claiming he's a supervisor, which I don't see anywhere where that's the case. But I'm bothered by Mr. Weiss, who is a consultant, and he's supposedly on the job. I can't imagine that he would allow that. I don't see how that could happen. So there's some interesting dynamics happening here. Mr. Jepson is overly qualified in what he has to say. I just think that really the board needs to really look seriously at what is a reasonable fine. And for me, 36,000 seems a little excessive. I do think, though, that Mr. Schmidt's at fault here because I think he was made aware that he was in violation. I don't necessarily believe it's $36,000 worth, but I do think he has failed to comply, and he has made it difficult. And I do believe, in my experience with Washoe County and with air quality, they've always been very accommodating. So but I just don't think it's a $36,000 fine. And what Mr. Jepson has to say, I think people need to read.
Can I make a comment? As I said earlier, we didn't receive this until shortly, I didn't anyway, until shortly before this meeting. I've not had an opportunity. I briefly looked at Mr. Pezzanella's because it's a short statement, but I see that Mr. Jepson's statement is quite lengthy. Could we have 5 to 10 minutes to at least read it before?
Yeah.
I have not received it. I'm not sure what we're talking about.
The appellant submitted additional documentation for their appeal quite late this afternoon.
Oh,
According to my quick glance at it before the meeting, it's 67 pages long. Needless to say, I did not have time to review that. And I'm just basing this off what our distinguished board member has said, that, we really need to read it. And I've not had that opportunity. I've read Mr. Schmidt's assertions in his statement, because we got that statement about, 5 or 6 times. So I did read his, but I've not read anything to support his statements.
Okay. There are 2 exhibits from Don Jepson. Each one is 1 page long. So if everyone has a copy of that, if you want to take 5 minutes to read and go over that before we continue this discussion.
I'm in favor of that.
Okay. So let's take 5 minutes. Everyone can read those 2 letters and we'll get back.
Thank you.
Thank you.
Yes, I've had a chance to read it. I don't know about everybody.
Madam Chair, this is Taylor Jenkins. May I ask leave of the board to clarify the building permit issue?
Yes, go ahead.
So building permit number WBLD 18-105119 was issued on 2/25/19. It was applied for on 4/6/18. I have a photograph of it, which I will be happy to track down the original document in my some 500 pages here and email it to the board if that is required or necessary. Thank you.
Can you just tell me what that permit was for? Is it a demo permit?
One moment.
And was it a request for an extension of the original permit that was issued in April of 2018?
So April of 2018 is the date it was applied for. It was not issued until February of 2019. There is only one permit.
Okay, because that permit actually is for tenant improvement and remodel in it. And it talks about the possible removal of damaged portions of the lodge and roof debris, but I think that's why it didn't fall under the purview of getting review from other departments, is because it was considered a remodel and a tenant improvement. Okay, is there a further discussion regarding the letter from Don Jepson?
I have a comment. I would strongly disagree with his assertion that the Washoe County Air Quality Management Division has no authority to do their job. I would strongly disagree with that. They were not acting in the capacity of a building inspector, and he is relating it directly to what a building inspector would do. And, I'm not questioning his bona fides. I've worked with Mr. Jepson in the past, and I find him to be very competent. That said, he apparently is under contract with Mr. Schmidt and has, some skin in this game, if you will. So I would strongly disagree with his assertion that the air quality doesn't have authority to enforce air quality issues, specifically as they relate to toxic air contaminants, such as asbestos.
My take on it was that the first letter was really more related to building officials and inspections and permit requirements, and whether they needed a permit to demolish or do renovations, and really didn't discuss asbestos issues or air quality at all. The second exhibit, he claims that he assumed that abatement would not be necessary and a demo permit would not be issued by the building department without approval from the health district, but there was no demo permit issued by the building department. And so that's kind of irrelevant because I'm pretty sure that in the past, when demo permits have been issued, they are sent to the Air Quality Management District for review and approval. That's
Yeah,
my
that
take.
was the only thing that I did have a question about. And I would pose this to both Mr. Vega and Mr. Ristori, is in your plan review workflow history, is there any evidence of seeing a permit application for any of the work that they're claiming that has been done to date? So anything, from my understanding, when permits are applied for through the building department, they go through all the county agencies for either pass through or some review and or approval or denial. And that I asked earlier if you ever saw anything like that, and you indicated you did not.
That's correct. I don't believe that we had the opportunity to review that permit.
Okay. So, and you had no opportunity on this subsequent, he indicates that the permit was applied for in April of 2018, yet was not approved until February of 2019. Is that correct, Mr. Jenkins?
Yes, that is correct, ma'am.
Okay. So you never saw that, Mr.
Yeah.
Ristori?
I do not believe the Air Quality Management Division was routed that permit or any plans associated with that permit.
Okay, thank you.
My question for air quality is that if a permit is for tenant improvement or remodel, you don't normally see those pass through your office, do you?
Yes, we do.
Okay.
Yeah. Yeah.
This is Richard. And Mr. Jenkins, I'm the legal member of the Air Quality Board. I would like to make a couple of observations. First, I think the statutes and regulations regarding asbestos abatement amount to literally a case of strict liability. You have the obligation to ascertain if there's a problem, provide notice to the appropriate authorities, and conduct remediation in accordance with their directions. I don't think there's any wiggle room. I think your client, as a matter of law, has a strict liability obligation to the health and welfare of the county. My second observation goes to the very cogent point of Mr. Kaplan. He said, every general contractor knows about the need for asbestos survey and asbestos safety. I submit to you, Mr. Jenkins, that your quarrel is not with the Air Quality Board of Washoe County. Your quarrel is with your contractor, whether it be Collins Construction or some other entity. They are the ones who fail to identify the asbestos regulations. I think you are the harmed party. I think you have a legal action against them, not Washoe County, not air quality. But nonetheless, I second Ms. Downs' motion that your client be fined the sum of $36,500 because of his strict liability and failure to comply with regulations. And I suggest to you, Mr. Jenkins, privately as one attorney to another, you know where you need to go now. Thank you.
And Madam Chair, this is Brian Sudi for the record. Just to be clear, there is no motion made yet.
Yes, I was waiting to see if there was any other further discussion among the board before we put forward a motion. Any further discussion?
I have a question, Kathy. I just want to clarify that the permit on February 26, 2019, I didn't get the number Mr. Jenkins provided, but that was for a tenant improvement. Is that correct?
Yeah, the permit was applied for in April 2019. I guess it was finally issued in February of April 2018, I'm sorry, finally issued in February of 2019, and that was for a tenant improvement remodel.
And there was no demolition on that permit?
The actual, what it said on the permit was investigative work to include recovery of historical building materials for repurposing and structural assessment of the lodge portion damaged by snow, and possible removal of damaged portion of lodge and roof debris with installation of a non-bearing weather-resistant end wall. Following phase will include contractor applying for permits for any structure repair or stabilization as outlined by structural engineering.
Madam Chairman, this is Richard Harris. May I have the opportunity to make a motion?
You may, as I assume we have no further discussion. Go ahead with your motion.
I move to deny the appeal of notice of violation numbers AQMV 21-0002, AQMV 21-0003, AQMV 21-004, and AQMV 21-005 associated with case number 1299 issued to Gary R. Schmidt with a $36,500 administrative fine.
For the record, let me correct that it's case number 1229.
What did I say, madam? Case number 1229, yes.
Okay, do I hear a second?
Yes, ma'am. I second that motion.
Okay, a motion has been made and seconded. Can we take a vote? Paul Kaplan?
Madam Chair, it would be appropriate to allow discussion of the board before you go to vote.
Okay, thank you for that clarification. Is there any discussion on the motion and second? Okay, call for the vote. Jeannie Rucker? I'm sorry. Jeannie?
Jeannie, you're offline.
She's muted.
I'm unmuted. I vote in favor.
Okay. Yvonne Downs? I think you were muted as well.
Can you hear me now?
Yes.
Okay, I do vote in favor.
Lee Squire?
In favor.
Richard Harris?
In favor.
Jim Kenny?
In favor.
And Paul Kaplan?
Having a hard time with the amount. I'm sorry, I'm just having a hard time with the amount. I think I know this is a bad time for a question. Is there any variables with the amount, or is that a hard number, period?
Correct me if I'm wrong, Brian, but if we have a motion on the table and a vote, is that too late? He can vote nay, correct? But there's no further discussion?
Correct. There was no discussion and it's to vote now. So it's on the motion with the fine stated in the motion. So yes, his option would be to vote nay.
Then I vote no.
Okay. The majority is in favor, so that appeal has been denied and the fine in the terms of $36,500 has been upheld. Any further board comment on other matters?
Madam Chairman, this
Yes.
is Janet. For the record, the appellant, through his attorney, Mr. Jenkins, has received the notification, has signed for it, that this is a recommending body only, that the recommendation of this hearing board will go to the Board of Health at the May 27th, 2019 meeting that begins at 1 o'clock. He has received that notification and signed it. It further indicates that if they wish to appeal to the District Board of Health, they have that right, and that has to be provided to this body within 5 days, 5 working days, which would actually be the 16th of this month, in writing to the district health officer that they further wish to appeal your recommendation. So that is part of the record.
Thank you, Janet. Any board comments regarding other announcements, reports, updates, or other matters?
If I may I have findings of fact on this?
Let me ask that question of Brian. I'm not sure. We've never had that before.
Taylor, this when this isn't in an administrative hearing concept. This is in a public open meeting law concept. And so they don't do, each board member won't do that. So the discussion would be what you're looking for, and that already occurred as part of the record.
Yes,
So
and-
Fair enough. Thank you, Brian.
you're welcome.
yes, and for the board's edification is historically, we only have findings of fact if there has been a variance request applied for. That's when findings of fact come into play. And Dr. Fitzgerald is correct in that we have never had findings of fact in a hearing appeal before.
Okay, is there any other public comment at this time?
I have a question about the historical document or the historical items to be retrieved. That is another regulation with the state in case that falls under SHPO.
Okay, duly noted. Thank you. The next item is adjournment. Do we have a motion for adjournment?
Oh, for sure.
Do we have a second? Okay,
Second.
all in
Have
favor?
multiple seconds.
All in favor, yes.
Aye.
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 Okay, meeting is adjourned. Thank you very much for your attendance.
And thank you all the board members for attending.
Thank you.
Thank you, everybody. Appreciate your time.
Good night.
Bye.
Good night.